So as the chief said, my name is Dan Bress, and on behalf of the Ninth Circuit Education Committee, it's my privilege to introduce the distinguished speakers for our annual Supreme Court review. Pam Karlan is a professor of law at Stanford Law School and a founder and co-director of Stanford's Supreme Court Litigation Clinic. A leading expert on the political process and anti-discrimination law, Professor Karlan was also a Deputy Assistant Attorney General in the Civil Rights Division of the Department of Justice. She has argued 10 cases before the United States Supreme Court. Before joining the Stanford faculty in 1998, she was a professor of law at the University of Virginia School of Law. She was a law clerk to Judge Abraham Sofar of the United States District Court for the Southern District of New York and to Justice Harry Blackmun of the Supreme Court. Jeff Wall is a partner at Sullivan & Cromwell, where he leads the firm's Supreme Court and appellate practice. Jeff is the former acting Solicitor General of the United States. He also served in the SG's office as the principal Deputy Solicitor General. He has argued more than 30 cases before the U.S. Supreme Court and numerous cases before federal and state courts of appeal. Jeff is a former law clerk to Judge J. Harvey Wilkinson of the Fourth Circuit and Justice Clarence Thomas of the Supreme Court. So Pam and Jeff will have a conversation for roughly 50 minutes, and then we will answer questions for about 15 to 20 minutes. There are blank note cards at your tables, and so during the talk, if you have a question, go ahead and write it down and just hold your hand up, and one of our staff members will come by to pick it up. So without further ado, please join me in welcoming Pam Karlan and Jeff Wall.
So thank you, Judge Bress. Thanks also to your colleagues, the conference organizers, for having us. It's always a delight to talk to Pam about the court's term. It's gotten harder because it used to be that you could do a Supreme Court preview in the fall with some assurance about what the court was going to decide during the term. And then you do a review or a wrap-up at the end of the term, as we're doing. And it's gotten harder and harder because of the emergency docket and the fact that we now no longer know as much of what's going to come up during a term at the beginning as we do by the end. I want to start, Pam, with sort of an odd claim, which is that by modern standards, this was a boring term on the merits docket. You had Skermetti and two religion clause cases that we'll talk about. Those were very important. Other than that, though, the merits docket didn't have a series of blockbusters like what we've seen in recent years. And if you look ahead to 2026, the court's docket so far for next year, I think it is fair to say, is not earth-shattering. It's a collection of sort of smaller, more minor questions, a number of them procedural or technical in nature. And I think what's causing that, it's just a guess, is that so much of the action is on the emergency docket. In the first Trump administration, the administration went to the Supreme Court on an emergency basis 41 times in 4 years. That was really high by historical standards, but they had a great deal of success at the Supreme Court. Through the first 5 months of this term, the department, the SG's office, has gone to the court roughly 20 times, so almost once a week. It's a 4x increase from the first Trump term. They've enjoyed, by the way, even more success. They've won almost all of the cases that they've taken to the court, and I think at the moment it's something like 15 in a row. We could all talk about, and maybe we will during the Q&A or later on in the conversation, about why that is, what the causes of that are, is that a good thing or a bad thing, and who's to blame. I'm just focused on the effect it's having on the merits docket, because on the emergency docket, the court is deciding some pretty important questions. Not all of them, to be sure, but you take something like Wilcox. One of the key questions about overruling Humphrey's executor has always been, what will that mean for the Federal Reserve? Does that mean the president can fire Chairman Powell? That's a really important question. Turns a lot on, one might think, things like history, things that you would think the court would want fully briefed. There was some of that in Wilcox, but not much, and the court, in its order, saying that the president could discharge a member of the NLRB, said, but look, this obviously doesn't apply to the Federal Reserve because of the first and second banks of the United States. We have a historical analog for this. The court says that in a couple of sentences, disposes of that issue. It's a really important thing going on the emergency docket. And I think it's crowding out the merits docket. As I say, if you look at next term, when I clerked at the court 20 years ago, the core of the court's docket, antitrust, securities, class action, civil rights, Fourth Amendment cases. And so far, at least for next year, I don't believe there are significant cases in any of those areas. So at least for me, as I look at the court, one of the things that I see is not just a shrinking merits docket, but an emergency docket that's changing the composition of the merits docket, because the court's not just leaving room for those cases, but they know that they're going to have to decide some really important questions, and it's influencing the cases that they put on the merits docket.
Yeah, I mean, I think that's right, and it's such a pleasure to be back at the Ninth Circuit. We're not going to talk about the cases our clinic did from the Ninth Circuit, because luckily we managed to file successful briefs in opposition in those cases. So those cases are not on the docket this year, not on the docket next year. I think there are also two other things that go into the fact that the court is not hearing very many cases right now, and historically this is really close to their low. One of those things is the way the rule of 4 interacts with the current membership of the court, which is that the liberal side of the court has no ability to put anything onto the merits docket right now because there are only 3 votes. And we saw several noted dissents by all 3 liberal justices. But of course, they don't tell you all of the times that they voted to grant certiorari and there aren't enough votes to grant. Second thing is Congress is doing almost nothing. And a lot of the court's docket in recent years has been responses to major litigation. So the Affordable Care Act, there was one case up there this year from the Affordable Care Act, Kennedy against Braidwood management case. But there's not any new legislation driving those cases forward. And so I think those things also cause the court to have fewer cases on its docket than it might otherwise have. I think at the beginning of this term, they were worried about whether they would have election cases to decide, and that kind of kept their numbers low. But they really are about as low in numbers as it's possible for them to get. I think if they get any lower than this, there'll be some noticeable public reaction to that.
I think that's right. Should we turn to CASA? More thoughts
Sure.
on the term? So,
I had one other thought on the term, which is, although the court kept its numbers down quite a bit, they had 5 cases that they took for oral argument on the merits that they didn't decide at all. 3 of those they dismissed as improvidently granted, and I think we've talked about this a little bit between ourselves. But what's interesting in those cases is those were all cases brought up to the court by very experienced business lawyers who managed to have the right buzzwords to get the court to take the cases, in which they argued for very broad rules. And then once they got the case in the door, they sort of changed how they were going to argue the case. In 2 of those cases that involved securities, and the court dismissed as improvidently granted. That may also be a product a little bit of this emergency docket, which is they just don't see the point in wading through a pretty fact-specific case when they've got all this other stuff going on. One case they affirmed by an equally divided court. This was one of the religion clause cases they had up there. It was about whether Oklahoma could have a charter school that is overtly religious. It was going to be the St. Isidore of Seville charter school. It was going to be a remote school. And the favorite fact I have about this is, why is the remote charter school called St. Isidore of Seville? It's because Pope John Paul II named St. Isidore of Seville the patron saint of the internet. And you might wonder, how do you get somebody from the 6th century to be the patron saint of the internet? And the answer to that is, he wrote something called the Etymologica, which was supposed to be a compendium of all the knowledge in the world in 600. So he was sort of like the Wikipedia of the Vellum age. But that case was affirmed by an equally divided court, which I think was a pretty predictable result in some ways, given that Justice Barrett was recused. And then in a very important voting rights case that the court has in front of it that pits the question of Section 2 of the Voting Rights Act and vote dilution against the Shaw line of cases about excessive race consciousness, on the last day of the term, the court announced it was going to have re-argument in this case this coming year, but they haven't yet announced what they said they were going to do, which is some supplemental questions for the parties to answer.
Yeah, I'd say as a member largely of the defense bar, I think the digs, the dismissals as improvidently granted in Facebook and video are a little frustrating because it feels very hard to get the court to grant in some of these core areas like antitrust or securities or class actions, and then once they're granted, as soon as you acknowledge that although you have a rule, there may be some nuance or some exception to it, it does feel like, well, you're out the door. I still think the lower courts could use guidance in those areas. I wish the Supreme Court would go on to decide them. Is it not doing that just because it's had a shrinking merits docket for many, many years, or because of the emergency docket? I don't know, but it does feel like it doesn't take much to get you kicked out even once you've gotten granted. So the first case we're going to talk about is a case from the emergency docket that went on to the merits docket, right? You could respond to the emergency docket in one of two ways. You could try to address its root causes and actually get rid of it, since for a very long time we didn't have it. Or you could institutionalize it. And at least so far, the Supreme Court seems to be doing the second. For certain cases on the emergency docket that the court deems of sufficient weight and importance, it will move those cases over to the merits docket, have full merits briefing and argument, and here in this case, CASA, it did it as a special sitting in May. The question is, can you have nationwide or universal injunctions? This is one of the birthright citizenship cases, but the government didn't take to the court the merits. It took only to the court the question of the scope of relief, arguing that both as a matter of Article 3 and courts' equitable authority, courts have no power to issue injunctions beyond what is necessary to provide complete relief to the party or parties before the court. The Supreme Court didn't decide it on Article 3 grounds, which leaves open the possibility, however unlikely, that the Congress could grant courts the power to issue universal or nationwide injunctions. But it did decide it as a matter of court's equitable authority. Back in a case called Grupo Mexicano in 1999, the Supreme Court said that courts' equitable authority under the Judiciary Act of 1789 is limited to remedies that were traditionally accorded by courts of equity at the time, the late 1700s, when the Judiciary Act was adopted. And in CASA, the Supreme Court said, universal injunctions lack any historical analog in English or early American practice. So you can only issue injunctive relief aimed at providing complete relief to the parties. Now, to be clear, the court said, lots of times other people benefit. If you tell the defendant that he's got to turn down his loud noise at night, that benefits all the neighbors, not just the one who sued, but it's necessary to give complete relief to the one plaintiff who did sue. But the court said in the birthright citizenship context, as soon as you say that the plaintiffs themselves or their children do in fact have citizenship, it isn't necessary to provide them complete relief, the court says, in order to extend that same remedy to others who are not plaintiffs before the court. I think the interesting question is, many of us have said for many years this was coming. It took the court a very long time to do it. The question is, how much is it going to shrink the emergency docket? I think the sort of common perception is it's going to make a big difference. I'm a little less sure for three reasons. The first is the APA says you shall set aside rules, and there's been a debate for a long time, set aside with respect to the plaintiff or everyone. The Chief Justice and Justice Kavanaugh have signaled that they may think about the APA differently than they think about courts' inherent equitable authority, in which case, in any challenges to government rules, you'd still have universal relief. Second, state standing. In the wake of Mass v. EPA in 2007, states have increasingly had standing to come into court and challenge all manner of executive actions. The government claimed in CASA that the states shouldn't have standing because their claims were derivative of the individual plaintiffs who were challenging the lack of birthright citizenship under the president's EO. The court didn't decide that. And then the question became, well, if the states are properly before the court, the states had an argument that they needed quite broad, even nationwide relief, because people move across state lines, and how are they going to run benefit programs that depend in any way on citizenship without a uniform rule that extends across the country? The Supreme Court ducked that question too and sent it back to the lower courts, remanded it for the lower court to determine what was the scope of relief that would be necessary to provide the states complete relief, but no more. But in a world where states have standing to sue, I think the CASA will be less meaningful as long as states are plaintiffs. And the third thing is class actions. Somewhat to my surprise, the Solicitor General offered up that there are examples of emergency or expedited certification of classes. He resisted the notion that you could do that in birthright citizenship, but he didn't fight the notion that courts could do it if you could otherwise satisfy Rule 23's requirements. I think that's going to mean that a lot of the fight that we've been having over nationwide injunctions and universal vacatur under the APA is going to shift to Rule 23. Immediately in the wake of CASA, Judge LaPlante in New Hampshire certified a class in the birthright citizenship cases. All of this made Justice Alito ask an argument, wait a minute, if you could certify classes in all these cases, like, what are we doing? What is this whole debate about? He wrote separately in CASA to say to courts, look, you need to be careful about certifying. Rule 23 has requirements. But I think you are going to see courts increasingly certify in these cases and plaintiffs asking for it. And that seems to me to pose a whole host of questions under Rule 23. What are you going to do with notice? Do you have opt-outs? When you have multiple class actions, are you going to MDL it? How are you deciding on class counsel? Is class certification still discretionarily reviewed the way it has been under 23F? All sorts of things that we haven't had to answer because we haven't been using Rule 23 by and large to certify classes in these politically charged challenges to executive action. But that seems to be the coming fight over the next few years.
Yeah, I'll just make two observations about the case. One of the things that I found most striking at the oral argument was that the Solicitor General, although he talked about the class action stuff, wouldn't commit that the government thought this was an appropriate case for a 23B2 class, which I find actually kind of stunning. And also wouldn't commit to obeying an injunction from the Second Circuit. And so he was asked, well, if the Second Circuit decides this issue, he says, well, generally we comply with orders by a court of appeals within that circuit, which again I thought was kind of stunning. And so the Supreme Court, in its opinion, says the Solicitor General does agree that the government will comply with an order from this court, which is something that I think up until then nobody thought was really something that needed to be discussed. Second thing I'll just say is that what this case reminds me of more than almost anything else is the Supreme Court's behavior on the question of interracial marriage in name against name, which is they are dodging an issue because I think they have a sense that at the end of the day they're going to have to hold this particular executive order unconstitutional, and they want to put that off for as long as possible because they don't want to have a conflict with the president, who has been, I think, and Jeff sort of alluded to this, very clever in what he takes up to the Supreme Court. That is, he could have taken up both the question whether there should be a nationwide injunction and the constitutionality of the executive order, but chose not to take that second question up there at this point. And the court could have manned up and just announced, we're ordering you to address this question as well, and I think it's telling that they didn't do that. I'll turn now to another case in which the government took an interesting position, and the court also did, and that's United States against Skermeti. It's a case that involved a challenge to both a Kentucky and a Tennessee statute that barred certain forms of gender-affirming care for transgender minors. Originally, the Tennessee case was brought by private plaintiffs, the parents of children who are seeking this care, and the government intervened. The government has the power to intervene on equal protection grounds in any case in federal courts. This is something that comes out of the 1964 Civil Rights Act. The case went up to the Court of Appeals, which upheld the preliminary injunction that had been granted in the case, and both the struck down the preliminary injunction that had been granted by the district court. Both the United States and the private plaintiffs sought certiorari in the case. The Supreme Court granted only the United States' petition, which raises only the equal protection issue, and not the parents' petition, which also raised a substantive due process claim involving the upbringing of children. The case was argued in the fall, and the government then, as you know, there was an election. And in February, the government wrote a letter to the Supreme Court saying, we've changed our position. We now think we should lose. But instead of then asking to have its petition dismissed, I think the government, reading the tea leaves from the oral argument, said, go ahead and decide the case anyway, which is a kind of interesting move on the government's part because they've already decided that they should lose the case. There's not actually any adversity at this point between the government and the respondent, but the court went ahead and decided the case anyway in a 6-3 opinion written by the Chief Justice, which said that rationality review should apply to this law because it does not involve sex discrimination. This, I think, was a very surprising move on the court's part. I would have thought that the court would have done something along the lines of what Justice Kagan alluded to in her separate dissent, which is to say, yes, this is a law that does treat people differently based on sex, because the sex a child was assigned at birth determines whether he can get access or she can get access to these particular treatments, but it satisfies intermediate scrutiny, and I would have expected the court to go there. The problem with that is the case was up on a preliminary injunction, so it would have required a remand. And so what the court did instead was to say, this is not a law that classifies on the basis of sex, even though in the statute itself it says that the purpose of the law is to get children to identify with the sex they were assigned at birth and to celebrate that sex, but is instead just a law that classifies on the basis of age, which rationality review applies to, and on the basis of the specific treatment for which a drug is being prescribed. And so that's kind of where the court landed, is it said neither of those requires heightened scrutiny, therefore this law is subject only to rationality review, and given the controversy over these treatments, a state could reasonably decide that they should be denied to minors.
So I only one or maybe two thoughts. I think that part of the reason I think the government was in a jam was I think there were multiple petitions. It wasn't just the government's petition. The private parties had brought a petition too. So even if the government had gotten rid of its case, there was still a live controversy in front of the court that it had already granted. And I think that's sort of unfortunate, many times over. Pam and I have talked about this a little bit, which is, Pam prevailed in Bostock. But not just because she gave a brilliant argument, but she had clients in the form of a child welfare advocate, and I think it was a skydiving instructor and a funeral home employee, who had been discharged simply for the fact of being gay. I don't think there were any job performance allegations. Their employers learned they were gay, and then they were discharged. So it was a case of overt discrimination or animus. If that kind of a case had come up here in the transgender context, I wonder what the court would have done. Now, maybe it wouldn't have been any different. Justice Barrett, somewhat oddly, wrote separately to say that transgender status is not a suspect class. She has been, I think, maybe the most incrementalist of all the conservatives, and has been sort of the most reluctant to reach out and decide questions she doesn't have to, along with the chief. So it was a bit of an odd thing for her to do. Maybe, given that's where she was, that it wouldn't have changed it at all. But it would have made the case more difficult, because it would have been more difficult to articulate the state interest on the other side. Instead, it came up in this context where the science and evidence over gender-affirming care is vigorously disputed by both sides. And that seems to me a less favorable context than what you had in Bostock. And I think even more worrisome for people who don't like the result in Scrimeti is that the court has granted for next term this transgender in sports case, a West Virginia law that does not allow biological students to cross over and compete in sports in the gender in which they identify. The district court enjoined that, I think took back its injunction, the Fourth Circuit reinstated the injunction, and the Supreme Court granted the case. That, again, is not the most favorable context for advocates of transgender rights for the Supreme Court to decide the issue. I suspect, given what we've seen from the court in terms of Dobbs in this case, we already know they don't like reading the Equal Protection Clause expansively. We know it's not a court in general, or this specific court, that likes to lead on hot-button issues. I think the scent is probably in the wind on the West Virginia case, but it goes to show the importance of agenda setting and vehicles at the court, because I wonder how this all would have turned out if the private parties hadn't tried to take this case to the court or had been willing to get rid of it when the government, as you say, essentially took away their controversy. I don't know, but I think it would have, maybe it would have been different.
Yeah, I mean, the Ninth Circuit case is also up there on transgender athletes. And that case is a Title IX case, which you know, the Supreme Court tried to think a bit in Scrimeti to say, well, the because of sex language that appears in Title VII doesn't appear in the Equal Protection Clause. And so it does appear in Title IX. So it'll be interesting to see what happens there. My Machiavellian suspicion about why the Supreme Court didn't also take the parents' case in Scrimeti goes to the next case we're going to talk about, which is a case called Mahmoud against Taylor. And I think that it would have been a bad look for the Supreme Court to take two cases involving parental rights, one on behalf of transgender kids and the other on behalf of parents who object to the existence of transgender kids, and decide them in opposite directions in the same term. So Mahmoud against Taylor involves the Montgomery County School Board's decision to eliminate its program for telling parents ahead of time and then allowing parents to opt out of a classroom in which a teacher reads from any one of a variety of books that involve transgender or gay individuals. The lead book, if you will, in the case is something called Uncle Bobby's Wedding, which is about Uncle Bobby who decides to marry his male partner. And initially, his niece is very upset because she thinks this will prevent Uncle Bobby from devoting all of his time to her. But the parents explain that there's more than enough love in the world to go around, and this love will include Jamie, the male partner, once he's in there. There's also a book about a young transgender kid. And Justice Alito's opinion for the court, 6-3, this case also involves an interesting way of taking a case up to the Supreme Court, because it's up there on a preliminary injunction. So there's not really a full record. And it was up solely on the question, technically solely on the question presented, of whether it burdens a parent's free exercise rights for the parent not to be given notice and an ability to opt his or her child out of the classroom. And a bunch of culturally conservative parents brought this lawsuit. And so theoretically, the only issue up in front of the court was whether there was an undue burden on someone's religious exercise for not being able to opt their child out. But in reality, the court decided the full case because it said not only did they think it was likely that there was a burden, but that this burden was unjustified. And I think in doing this, the court moved quite a bit beyond the existing cases. So the existing cases on burdens involved things like mandatory attendance requirements that required you to go to public school. That was the Meyer against Nebraska case. Or the Yoder case, which was mandatory school attendance at all after the 8th grade for Amish children. But there wasn't any case that involved the right to kind of selectively opt your child in and out of different parts of a public school system. And the court here said this is a burden on the parents' rights. Justice Alito's opinion for the court said this is in part because they're not just telling you that same-sex weddings exist, they're celebrating this, and this involves indoctrination of school children. And I think having decided this case, the court is going to find itself in some difficulty, or lower courts are going to find themselves in some difficulty as parents seek to opt their children out of lots of other aspects of school. So what do you do with a science class in which a parent says, the world is 6,000 years old, I want to opt my child out of evolution? Or what do you do if you think about some of the executive orders that the Trump administration is putting in about what should or shouldn't be taught about American history to a parent who says, I am a Christian nationalist, I want to opt my child out of a lecture about the Civil Rights Act, or my religion teaches that all people are equal but equally sinful, and therefore I want to opt my child out of a class that tells them in any way that they are responsible for the various problems the country faces. Or like, I find it hard to believe the court would have allowed would have decided the case this way if it were parents objecting to evolution, but I do think that especially transgender rights right now is the cultural war issue that's going up to the Supreme Court the most.
Yeah, so in some ways I see the difficulty maybe even more acute, though I might be a little more sympathetic to what's behind it. I mean, for a very long time, just taking a step back, the court took an extremely robust, really separationist view of the Establishment Clause, and it gave far less scope or work to do to the Free Exercise Clause. That's now really shifted. You can say the pendulum has swung, and now it's all free exercise clause, and there's not much left of the establishment clause, or you can think that it's brought the two into balance. But whatever one thinks about it, there are sort of two ways in which the court has done that, or two sets of cases. The first set of cases is access to like a government funding or benefit. That's a case like Drummond. And the courts had a trinity of those cases: Trinity Lutheran, Espinoza, Carson v. Maker, and in all of them it is found that the religious claimant should be afforded access to the government funding or benefit. Drummond is sort of the ultimate along that line. Can you have a religious charter school? 4-4, court gets rid of it, but the issue will come back. And if the religious charter school wins in Drummond, then I don't know how much is left of that category of cases. I'm not sure how many claims you can come up with where you would be denied access to the government funding or benefit if the religious claimant prevails in Drummond. Where I think the action remains is the other set of cases where you claim an exemption or an accommodation from some neutral, generally applicable law, non-discrimination mandate, or what have you. There have been a number of those cases in recent years. Mahmoud is the latest. As Pam knows, the bottom line is the religious claimant for the accommodation virtually always wins. I'm somewhat sympathetic to what the court is doing there because I am deeply troubled when the law forces someone to violate their religious beliefs. But I think if you take the sentiment seriously, you're going to need to reconsider Employment Division v. Smith. I mean, that's Justice Scalia's opinion for the court, saying that the free exercise clause does not entitle you to an exemption or an accommodation from a neutral, generally applicable law. And so to date, these accommodations have come by statute under things like RFRA or RLUIPA. And cases like Mahmoud seem to me pushing against that notion. And I think that ultimately the court probably will end up reconsidering Smith. But then, as Pam says, you are really going to have to dive into a lot of questions that the court has avoided for a long time, like what is a sincere religious belief and what counts, because you're going to get lots of different claims for accommodations or exemptions that, as Pam says, the courts may not be as hospitable toward as they are the claims in Mahmoud. So I don't know if you think that's where the court's going, but it seems to me that's where we're headed.
Yeah, and of course the solution from the school board's perspective is to just dumb everything down or avoid any controversy at all. That is, take the Uncle Bobby's book out of the classroom because the idea that you're going to have children going in and out of particular classrooms based on which stories other kids in the class pick from the bookshelf to ask the teacher to read, just that way lies madness. And so the only solution is going to be a solution that takes everything controversial out of the school system, and that's probably a bad thing.
Yeah, I will say the school district's defense of the Supreme Court was sort of interesting because at oral argument, the advocate really tried to run away from the notion that these were value-laden books who were meant to achieve any of this content education, as opposed to just saying, look, we're not required to give an accommodation. These are decisions that should rest with local school boards. And in Montgomery County, Maryland, we can make a choice that we want to teach things that they don't want to teach in counties that are more conservative. And they ran away from that notion pretty hard in the Supreme Court, and I think it was hard to take the line that they did and cobble together any support.
Yeah, I mean it's a tough issue because theoretically the only thing that was up there was, does this burden the parents? And this goes back to your point about sincere religious belief. If somebody says, this burdens my religion, how do you say, no, actually, we don't think your religion is burdened at all?
Yeah.
It's a little bit of a tough move once you get away from the cases like Little Bird of the Snow, Roy, or the logging case.
Yeah. So non-delegation. Court had a case this term called FCC versus Consumers Research. And it was, I don't know if any of you ever checked your phone bills, but if you have, you might find there one of the little line items is a universal service fee. You pay a fee, we all do, And that fund, the Universal Service Fund, pays for the extension of various telecommunication services to rural and low-income communities throughout the United States. The way that the statute operates, Congress delegated the authority for setting the amount of this fee to the FCC, which delegated it in turn to a private or quasi-private body, the USAC, which is just the Universal Services Council. And some challengers brought a non-delegation challenge to the operation of this scheme, and the Fifth Circuit sustained it. And what the Fifth Circuit said was, we think likely the delegation from Congress to the agency, the FCC, violates the non-delegation doctrine. And we think it likely that the delegation from the agency to the council, the private or quasi-private entity, violates the private non-delegation doctrine, that you can't hand government executive authority off to private individuals. But we don't need to decide that, because taken in combination, we find a violation of the non-delegation doctrine. The Supreme Court had reversed the Fifth Circuit in very similar reasoning in a case involving the CFPB's structure last term. The court does not like this kind of hybrid reasoning and doesn't like it across the board. Doesn't like it with respect to constitutional claims, doesn't like it in other areas. There's a case called Linkline where the court said you can't take one failed antitrust claim, put it with another failed antitrust claim, and together make a meritorious course of conduct antitrust claim. They're just not a fan of trying to collapse various doctrinal boxes once they've set the box up. So from the get-go, the hybrid reasoning probably wasn't going to work. So then it was just a question of whether the two delegations, one to the agency and one to the private entity, were themselves permissible. And the court said that they were, that the one to the FCC had been sufficiently constrained by Congress, and that the one to the private entity was fine because the FCC retained all of its decision-making authority and had powers of oversight over the council, which was in effect making recommendations that were adopted if the FCC did nothing, but the FCC always had the power to act. As it turns out then, the case doesn't end up being all that significant, because it would have been a big deal, I think, potentially, if it had gone the other way and really reinvigorated the non-delegation doctrine. But as is, it's just another in a line of cases, like Gundy a few years back, rejecting a non-delegation challenge. Here's what I think is really going on. For years, people have said, look, the Supreme Court wants to reinvigorate the non-delegation doctrine. I think there was a point at which that was true, but I think the rise of the major questions doctrine has sapped a lot of the force of that. Because if you agree that in anything that is a major question, Congress has to speak clearly, or the agency will not be taken to have the authority. And if everybody agrees, as all 9 justices do, that you can give ministerial stuff to the agency, then reinvigorating the non-delegation doctrine would now operate only in the middle ground, which is to say the cases that by definition are not major questions but fall somewhat short of being just ministerial. And I don't think that a majority of the court is as interested in doing that once you have the major questions doctrine. They got kind of pushed into taking this case. There was a circuit split. Both sides petitioned, including Solicitor General Prelogger. I think it was just tough for the court not to take it. But I will say the court still did make one interesting move, and I'm curious to see how it plays out over time, which is the court sort of set up, it wasn't express about it, but I think what it was doing was, it seems to sort of set up a sliding scale and say, look, when you get to full-blown major questions, Congress has to speak clearly or you can't do it. But of course, the more important a thing is, the more guidance Congress needs to provide and the more specificity it needs to provide. So I think that, I'll be curious to see, but I think for judges who still want to give real heft to the non-delegation doctrine, there will be some set of cases out there where they will say, well, it's short of a major question, but it's sufficiently important that I still think Congress needed to be clearer in this statute than it was. But I think that's a much smaller set than it would have been if the court had gone the other way and said, oh, this particular statute violates the non-delegation doctrine.
Do you think that Loper-Bright is also going to play into that in a way, which is now that the court has decided that they don't have to defer to the agencies, a lot of the things that would have been decided on non-delegation grounds, if they don't like them, they're just going to say, we don't think the statute goes that far.
Yeah, so I'll give you one interesting example. I argued, I had the net neutrality case in the Sixth Circuit recently. Obviously, that's one that is flip-flopped across administrations. We got a stay from a Sixth Circuit panel, which was an ideologically diverse panel on major questions grounds. And when I showed up for the merits argument in front of the panel, which was a different panel, the first words out of my mouth were major questions doctrine, we already got a stay, you already figured out we were likely correct. And in the first 30 seconds, Judge Kethledge said, not interested in the major questions doctrine. I'm only interested in the text of the act. My colleagues may be, feel free to talk to them about it. I only want to talk about the text of the act. And the argument was dominated by a discussion of the text of the Telecommunications Act. And the Sixth Circuit, notwithstanding what the state panel had done, decided it on the text of the Telecommunications Act and said that the act did not allow the FCC to adopt the regulations at all. So I do think you're starting to see more of that from courts that are, yes, there is some interest in the threshold stuff, but there's a lot of interest in just going to the text.
Yeah, and you talked a little bit before about Wilcox. I don't know if you want to talk a little bit more about that, but the other place where you saw the Fifth Circuit getting slapped down was Kennedy against Braidwood Management, which was about the essentially quasi-private but appointed panel that decide which preventative care services are covered under the Affordable Care Act. And the Fifth Circuit treated that as a group of people who had to be, who were principal officers and therefore had to be appointed by the president with the consent of the Senate. The court decided no, didn't have to be, because these people can always be fired from their jobs by the Secretary of HHS, who then can retain control over what actually goes into the package of preventative services. Yep. And I think that's the same kind of thing going on there.
Should we talk about the emergency docket?
Why not?
Yeah. You want to start us off?
Because otherwise we would have to talk to you about some incredibly boring cases that the Supreme Court decided on its merits. So I want to start actually with the most recent one of them, which was McMahon against New York. This is the case about the essential kneecapping of the Department of Education. This is one of the many cases in which the court issued a stay that does not explain which from among the 3 or 4 different arguments the government had made was the reason why they were staying the decision, essentially to fire half of the people in the Department of Education. And I think one of the things that the court is doing more and more here is by not explaining what's going on, it leaves no guidance to other courts about how they should be deciding these cases. That is, the Supreme Court has moved away, I think, from really talking about the 4 factors for a stay or for a preliminary injunction, and doesn't tell you what's really going on here. My own view is that in a number of these cases, the decision to stay is essentially the merits decision at the end of the day, because you can't remake what has been destroyed here. And that was, I think, Justice Sotomayor's point in dissent, which is once you fire all these people and you allow the firings to go through, it's hard to get them back, because they go on to find other jobs, they move to other places, they decide that their government job, even though it was a civil service job, is no longer secure, and so they're not willing to make the trade-off that they initially made between pay, for example, and the job. And so in a number of these cases, I think the Supreme Court should not be stepping in with unexplained stays, and almost all of them are unexplained. The only one that was really kind of explained in a way that I thought gave you a sense of things was Wilcox. And what they did there, I think, was almost entirely designed to kind of calm the markets by saying, whatever we do with Humphrey's executor, which I'm starting to call Humphrey's executioner instead, because I think they're about to get rid of it, whatever they do there, don't worry, we're not going to do it to the Fed. Which is, I think, the ultimate in pragmatic consequentialist reasoning by a court that claims never to do that.
Yeah, I think the court's in a tough spot on this one, which is, I agree with you that Justice Barrett seems to me to take the factors seriously and to vote against emergency relief when she thinks that the other factors aren't met or the government's showing of harm is outweighed by the private party's showing of harm. But the others, I think, really do seem to view it as much more of a merits-based determination. And I think Justice Kavanaugh's even been fairly explicit about it, that like, We set one uniform rule. We have to determine what the default rule is, what the status quo is going to be while this litigation plays itself out. And I think for most of them, it's just, who do we think is right? That party should get to control what the status quo is pending the litigation. The difficulty then is if that's the way you view it, you could say more about the factors, but you'd pretermit all the consideration in the lower courts, because as soon as you say that, at least in theory, what judge is going to disagree? I mean, technically, the court's only saying that they think that's likely to be the case, but how many courts are going to be willing to say that the thing that the Supreme Court just said is likely is in fact wrong, faced with the exact same arguments that were in front of the court? So I think they're trying to remain quiet in order to allow the lower courts to flesh out the grounds, but as you say, it generates a lot of confusion, and there is sort of an artificiality to it.
Well, the big artificiality is what's the status quo, right? The status quo was we had a Department of Education. The current rule is we don't. The court, I think, and this goes back to the Trump against the United States case last term as well, the court is acting as if we are in normal times, and at least for me, this is not normal. And the the huge changes in all sorts of things that had been well established for decades, it raises this question of when you want to preserve the status quo during litigation, isn't the status quo we have a Department of Education? Isn't the status quo any child born in the United States and gets a birth certificate in the United States can get a US passport and the like? And so if that's what you think the status quo is, then the Supreme Court is not preserving the status quo. What they're doing is allowing the stuff, and then the question is, psychologically, do they go back on that and say, we really shouldn't have stayed the decision to gut the Department of Education? I think, that's going to be, I think it's going to be difficult for them to walk some of this stuff back, even if, had they decided the whole thing on the merits initially, they would have decided it in a different way.
Yeah, look, maybe it's the former government lawyer in me talking. I think, the government would say, look, the status quo has to sort of fold in the legal rules and backdrops. And so you have to fold in that the court in Sela has already narrowed Humphrey's executor only to officers that don't exercise substantial power. It has to fold in that courts have historically said that you defer to the military, or that the president has a lot of authority with respect to the immigration laws. And so it's a little, I think it's a little difficult to figure out what is the status quo in some of these cases. Maybe not in a case like birthright citizenship, that one's easier. But I think at some of them it is tough. I mean, I'll give you one example. In the first Trump administration, President Trump issued an order that prohibited service in the military by transgender individuals. It was enjoined by courts, and the Supreme Court eventually lifted those injunctions. He did the same thing this time around, a virtually identical order, virtually identical injunctions. It went up to the Supreme Court, which again stayed the injunctions. Is that the court disturbing the status quo, or was it lower courts not understanding what really the right status quo was? I'm not entirely sure the right way to view it, but I do think if you divide it into buckets, it seems like the emergency docket really has fallen into sort of three buckets. The immigration cases, where the government has generally lost the cases where it was putting people on planes without sufficient notice, but has won most everything since then because it has stopped taking those cases up to the court in the wake of Abrego Garcia and a couple of others. Then there's the set of cases about reductions in force. It's generally won those cases because the court has signaled that it thinks the president should have the authority to reduce the scope and size of the federal government. And then the sort of Humphrey's executor cases. And again, the court signaled it's going to give a very narrow reading of Humphrey's executor. But of course, Judge Alicorn in DDC just ruled the other day with respect to FTC Commissioner Slaughter that she's covered by Humphrey's executor and that she's entitled to be reinstated at the agency.
It's hard to find an agency that's more like the FTC than the FTC.
In the FTC. And so, I mean, I think, tell me if I'm wrong, I think this is the Humphrey's executor case. I mean, I think the court has to take this and say either it still applies to the FTC and nobody else, or it's a dead letter and we're carving out the Fed. And it seems like in Wilcox, they suggested they're going to do the latter.
Yeah, it'll be very interesting. It'll be very interesting to see, especially if you think about one of the people who's up there in Wilcox is one of the members of the Merit System Protection Board. And if you take seriously the idea of a civil service, the idea that the people who protect the civil servants from the current administration don't get any protection themselves is going to be a tough line, I think, to walk. I'm sure this court will manage to walk it, but it is going to be a tough line for them to walk.
I think and by the way, I should say we've been so efficient that I think we're about ready for questions, so hopefully you have some collected. But I do think that in a clash between allowing the president to exercise authority over the executive branch, including the sort of hiring and firing of executive employees, and the independence of the civil service, I don't think it's difficult to figure out where this court will come out on that one.
Unfortunately so. But luckily, most of you in the room have life tenure, so
Yes.
you don't have to worry about this.
All right, so let's see. Here, I'll give you that one. That's a good one.
Okay. Any news sites on how the court is treating precedent? Not well. Not well at all. No, I mean, so one of the things about the court is there are some precedents that they have clearly had in their sights for years. I think Humphrey's Executor is a pretty good example of this. I'm intrigued by your point about employee division against Smith, because they've had that up there a bunch and have not seemed to bite on that yet. You know, the constitutionality of the Voting Rights Act, I think, is something that is kind of floating around. Interestingly, Justice Kavanaugh just gave a stay in an Eighth Circuit case where the Eighth Circuit held that there is no private right of action under the Voting Rights Act. That is, that voters who've been denied the right to vote or who allege that their votes have been diluted by redistricting schemes or have no private right of action, which is, I think, a stunning decision by the Eighth Circuit. That precedent, I don't think, is likely to go anywhere. At least I'm hopeful not. But you know, I think a lot of the members of the current court think that if they think a particular precedent was wrongly decided, there's not much in the traditional stare decisis factors that require them to stick with it.
So what is the status of the tiers of scrutiny? That's a great question. I think that the tiers of scrutiny are sort of something that the court observes, except when they don't. You lower courts do not have that freedom, and they haven't given it to you. But you know, there was a pornography case out of Texas, Paxton, and Texas had a law that required age verification in order to access porn websites. And the challenger said, okay, look, we understand that you may be able to do this with respect to minors, but you're placing a significant burden on the First Amendment rights of adults in order to access this pornographic material. And it didn't seem to me, going into the case, Pam's much more a First Amendment scholar than I am, but it didn't seem to me it seemed to me that the Texas law sort of had a fair bit to recommend it as a matter of common sense. Maybe that's because I'm a parent of a 10-year-old and a 6-year-old, and I sort of look at this in a different way in a world full of iPads and iPhones, but it wasn't clear to me that Texas could neatly satisfy the tiers of scrutiny or that they fit the case very well. And so the court ended up just saying well, all right, it is intermediate scrutiny, but you pass, which it wasn't obvious to me that it would satisfy intermediate scrutiny. And then Pam comes back and says, well, look, why not say that in Scrimeti? Why not just say it is sex discrimination? And you could say you want to pass intermediate scrutiny or you don't, but isn't that the right way to think about it? So I'm not sure what to make of the tiers of scrutiny, except that the court sort of uses them when it needs to in order to kind of, I think, jam results into them. But I don't know that I have a sort of unified view of how the court actually uses them in some really principled way.
Yeah, I mean, just two observations on that. One is, again, I thought Justice Kagan's dissent in that case was really interesting, because what she said is, I think strict scrutiny should apply to this because you're actually restricting the access of adults to material they have a First Amendment right to receive. Because the case was really about age verification for materials that are obscene as to children but not as to adults. And then she said, but you know what, I think this probably could satisfy it. I mean, she kind of hinted that this would be perfect, that the tiers of scrutiny are not what's going to determine whether this statute's constitutional or not. The only place where the tiers of scrutiny seem to be really rigorously applied by this court are in some religion cases, and then in race discrimination cases that involve affirmative action. Those are the two places where they're really sticking to it. But everywhere else, it's kind of, you know, I think there was a Johnson's baby shampoo slogan, "No more tears," and that's kind of where they are.
This must be from one of your co-clerks.
Professor Carlin, you're looking much better these days than you ever looked before. No. Have you had work done? No, but I just got back from vacation. No. Professor Carlin, you clerked for the Supreme Court in a year that many people consider the high water mark for the quality of the clerks. Do you ever look back and think what a privilege it was to work with such extraordinary people?
Are your co-clerks in the audience?
I don't. Helene, are you here? Because I'm pretty sure Beth isn't here, and I know David isn't because he just broke his ankle climbing on the bouldering wall at the Stanford gym. He's the second law professor in the space of about 6 months to break an ankle on that wall, which it should tell you something about both the fitness of our faculty and the danger of the wall. So. The short answer to this guy is I loved clerking at the court. I loved the people I clerked with. We did not win all of the cases that I was hoping our side would win, but we won a fair number of them. My co-clerks have gone on to do extraordinary things with their lives. We're still friends. I mean, I assume this is true for your term as well. You know, one of the big differences is I clerked at the last term of the Supreme Court, not only of Chief Justice Burger, but the last term in which large law firms did not pay signing bonuses to Supreme Court clerks. And the upshot of that was not that many people from my clerkship year went straight into big law practice. A number of people went to U.S. attorneys' offices. I went to the NAACP Legal Defense Fund. A number of people went into teaching. And I think actually one of the worst things that has happened to a generation of very talented lawyers is the huge signing bonuses. Because people don't go back into the government immediately, as a number of my co-clerks did. They don't go to small boutique firms as much as they would. After they go to the big firms, they're kind of aging out in some ways of going into teaching. So many fewer of them go into teaching. I don't know, but you probably benefited from the bonus.
Well, I would be happy to get rid of signing bonuses these days, but no. When I clerked, we got a bonus coming into firms, but it was a fraction of what it is now. It's now $500,000, and that, by the way, is universal. I don't mean I mean that is just the market bonus if you go to a big law firm. I think its origins started in kind of a healthy place. The idea was you had clerked for usually a couple of years. You had surrendered a lot of money in the meantime in order to clerk, and it was a way to sort of help make people hold on the back end and pay off some student loans. And it made a lot of sense to me when it was a much smaller number, and it didn't really, you know, when it started out at 50, 75, it wasn't really influencing career choices in the way that it is now. To turn away from that for just a minute, I will say that, this is a kind of a gloomy thing. When I clerked, and Judge Calabretta is probably here, he and I clerked together 20 years ago. And although there were a number of very big, very divisive cases that term, Raich and Booker and Kelo, the clerks got along incredibly well across the chambers without really regard to ideology. And we've had a number of clerks from our year who have gone on to become judges. Judge Calabretta is one, but we have Judge Packold in the Northern District of Illinois, Judge Richardson, Judge Van Aken in California. And without exception, I believe for every one of them, every clerk signed the letter to the Senate Judiciary Committee across the entire clerkship class. And I think that practice has fallen off in recent years, but it's more just a symptom of the fact that I think the court as a whole is a more fractious institution. Justice Thomas used to say of the Rehnquist court, like, we're a dysfunctional family, but we're still a family. You know, we don't all get along all the time, but we still have, there was a sort of a warmth and affection among a number of the justices that I saw when I was clerking. And I think that's less true now, and I think it's bled over toward the clerks, and I hope that pendulum comes back around. So some orders in the this one we touched on, but I think it's some orders in the emergency docket are relatively short, but with lengthier dissents. Should the court be issuing more reasoned decisions in emergency docket matters? I take it you think yes.
Either that or they shouldn't be granting so many stays.
Yeah.
Yeah.
So I think I'm a little bit more skeptical that they should, because I worry it cuts off the discussion. I think the really hard question is the one Pam just posed, which is, it is really easy to bemoan the emergency docket, but it is much harder to figure out like what you should do about it. I think it's really hard to fault the executive branch for going, given that they're prevailing and the pressures on any administration when one of its important policies is blocked to go to the court are always going to be very substantial. And the best argument that executive branch lawyers used to have about not seeking emergency relief was, well, you can't get it, so what would the point be? And that argument's not on the table anymore. And that's true not just for the government, by the way. In general, lower courts, my experience as a practicing lawyer suggests, are more willing to grant emergency relief than they were 15, 20 years ago. This is spilling over to the lower courts. It is easier to get rid of mandamus. It is easier to get emergency or expedited briefing, hearings and decisions by particular dates. All of this is sort of a thing that is now on judges' minds in a way it wasn't before. And it's a really hard question what to decide. What should we do about that? You're not going to get the executive branch to stop going as long as they're winning, or at least they have a reasonable prospect of winning. So you've either got to address the root causes of the emergency docket by limiting universal vacature, state standing, looking at associational standing, and not being willing to do everything under Rule 23 so that there isn't broad relief that forces the executive to go up. Or you have to say the Supreme Court's not going to grant relief, and we're just going to live in a world where the executive branch is going to be hamstrung across administrations by district judges in one set of states or another, or you're going to try to make it harder for district judges to grant that relief in the first instance. Back when I was in law school, it was an extraordinary thing to grant an injunction against a federal statute, regulation, or executive order. That's not the case now. And so those seem to me the only three solutions, and I don't, as much as people don't like the emergency docket, no one seems to cotton to any one of those three, and so I'm not sure where we go from here.
Yeah, I mean, I think the other thing is, of course, if you manage not to have these cases coming up on the broad issue, then the government can lose repeatedly and never take the case up because of the non-acquiescence doctrine. Mm-hmm. And that's problematic too. And I think in the CASA case, there was a bunch of questioning about that at the oral argument, which is suppose you get 15 of these cases, or suppose you get 94 of these cases, one in each district brought by a plaintiff, and they each win. If the government doesn't appeal any of those cases, then there's no way to get the issue to the Supreme Court. And if the Supreme Court really does view itself as Justice Kavanaugh's opinion in the CASA case suggested as, we're the decider on all of this, there's got to be some mechanism to get the issues up there.
Yeah, I mean, that's one of those things. It strikes me as sort of the thing that a problem in theory, but not in reality, which is to say, if when you have something like birthright citizenship and you are being enjoined all over the place, I think the pressures on the Solicitor General to go up to the court are enormous. And John Sauer said at argument, believe me, we're coming. I'll pledge to the court that even if we're losing, we're going to come. But that, I mean, that was Justice Kagan. One of Justice Kagan's big concerns was you're just losing across the board. You're going to shield it from us by never actually bringing it to us, but making people keep fighting you in the lower courts. And he said, no, I promise you, we're going to come.
Yeah, I mean, it kind of reminds me a little bit of Camreta against Green, which is this question about in qualified immunity cases. What do you do if you were a government agent who gets qualified immunity in a case, but you think you really need to get some decision on the merits? Can you take it up to the court? And the court really wrestled with that there. Okay, so this next one is, how do you view how Scrimeti applies to adult transgender cases? And I think that's going to depend on how the court thinks about the kind of Washington against Glucksberg issue. And the reason I think that is that if, for example, a state were to ban gender-affirming care for adults, the rationales that it gave in Scrimeti, which were about this is very controversial and there are arguments that it is irreversible and children shouldn't be making these decisions and maybe even the parents of children shouldn't be making them. Some of those arguments apply to adults as well and others of them don't. And in Washington against Glucksberg, you'll remember the court kind of differentiated between the right to physician-assisted suicide on the one hand and the right to refuse medical treatment on the other hand. And this is an affirmative medical treatment case as opposed to a right to refuse treatment case. And so I just don't know how the court would decide the issue there. I would be surprised if there are states that are going to pass these laws with regard to adults, but how the court would decide them, I don't know, given what it said in Scrimeti, which is this isn't sex discrimination at all, and rationality review applies because the court did say there it applies because it's both, the only things this statute differentiates on are age on the one hand and medical treatment on the other. But the medical treatment claim, if you take it out of the transgender treatment area, suppose the government passes a law that says you can't do an off-label use of this particular FDA drug. I mean, right now, most FDA drugs, you can do off-label uses. So the drug is supposed to be, a diabetes medicine, but they give it to people for weight loss or the like. If that's not something that the government can generally ban that, it just doesn't. And so if the government banned the use of particular hormones for gender-affirming care, I don't know how that would be different. Unless you treat it as it's a form of sex discrimination that needs some form of heightened scrutiny, or it's discriminating against transgender people, which needs some form of heightened scrutiny, and neither of those is something the court has yet said.
Yeah. So this is a great question, and Pam, I'm really curious for your views because I'm not sure I know the answer. We hear a lot about Justice Barrett's role on the court. How do you see her role? And I have to say, I think she's the most interesting of the justices to me at this point. She sometimes will cross over and vote with the more liberal members of the court. She will sometimes vote to deny emergency relief, even if she thinks that the challengers are likely to prevail on the merits because they haven't satisfied the other factors. She's generally cautious and incremental, but see the separate opinion in Scrimeti saying transgender status not a suspect class. She's an extremely incisive questioner at oral argument in a very gracious and civil way. She's not pointed or mean or hostile, but she, much like Justices Alito and Kagan, will just keep going until they can really pin down the answer to the question. I mean, she kind of, you can't get away. And so I'm not, it's too soon, I think, to give a verdict on what, her role on the court and how exactly she's affecting the coalitions. But I'm really curious for your view.
Yeah, I mean, I share your view on, and one of the things you said about how she keeps going on the questions reminds me of something else that has been a big change at the Supreme Court over the last couple of years, in addition to the emergency docket, which was during COVID, they didn't want to do Zoom arguments the way a lot of courts of appeals do, or I think because they really don't want their arguments televised and they didn't want to show that it was technologically possible to do that. So they did everything over conference call phones, which meant that they had to go to seriatim questioning as opposed to the free-for-all that they had previously done because they couldn't see each other. And some of them went to the bathroom during the oral arguments, which probably they also shouldn't have done, or at least hit mute. But they have kept, as they went back to their traditional argument style, they've kept this round that some people call the speed round, or like where an individual justice gets to ask questions. And it has changed oral argument in some really interesting and useful ways. And I think one of them is you can't dodge a justice anymore. It used to be that, if you were getting pounded by a particular justice, you develop pivots where you'd say, and that's all very interesting. And now I'd like to turn to this other question that you asked about a while ago, friendly justice who's trying to send me a lifeline. And now you can't do that. And I think some of the justices have used this to very good effect. The other thing that I will say, and I'm not just saying this because I'm sitting here with you, Jeff, is that I think one of the best things that came out of this is Justice Thomas started to ask questions at oral argument, because he asks very interesting questions. And also, sometimes he asks questions where you have an answer to what he's asking. But in the old days, you never got to give that answer. And so he would write a separate opinion saying, well, what about this? And you would say, well, if only you had asked, I could have said.
Yeah, when I was clerking for him, he rarely asked questions at the time, but he would say publicly he would say, look, I don't ask questions because when I came on the court, this wasn't the way we did it. Byron White, Potter Stewart, these guys, it wasn't a rapid fire round. We weren't cutting off advocates. We weren't talking over each other. And he used to say, I find the entire thing sort of unbecoming a Supreme Court. And the interesting thing is in the new format, he meant it. In the old days, Justice O'Connor always got the first question if she wanted it. And then it became Justice Ginsburg, always had the first question at argument. And now Justice Thomas, as the most senior other than the chief, always has the first question or two if he wants it. And then then it becomes sort of a free-for-all. And then, as Pam said, you do the seriatim where you go down the list. And if anybody had any questions that they didn't get in, they get to ask them. And it makes the arguments a lot longer.
Oh, yeah.
I mean, a lot longer. When Rehnquist was the chief, when the red light came on, you stopped mid-sentence, mid-word. And if you did not, he cut you off, and he invited you to sit down. The case was submitted. Arguments went for 1 hour and 1 hour only. Now, an argument can go 2.5, even 3 hours in a major case. And so they're going sometimes well into the afternoon. It's hard on advocates because we don't get to have snacks like the justices do. We don't get to just get up and slip out for a bathroom break and all. It's hard. But I will say that I may be a minority on this. I really like the new argument format. I'm a much bigger fan of it. These are huge cases. They're very important. The 1 hour did strike me as very artificial. In every case, is it good? No. Have we gone too far? Are there some where we could ask fewer questions and shorten it up? Yes, they could be an hour 15, hour 20. They don't need to be 2 hours. That would be. But in general, I think it's a really good thing, and in part for the reason you said, which is it puts a real premium on an ability and a willingness to answer a justice question, because you can't get away from it anymore. I mean, they can keep asking until they've really got you pinned down on their specific question. And I think that's a good thing. And that leads into, do I have time for one more?
Oh, it's Judge Red Light.
I'm supposed to keep us on schedule.
Well, you missed my favorite one. The Supreme Court bar seems to be more and more limited to a few leading advocates. Can you comment on this? Yes, I think it's great.
Loved it, hated it.
Okay, well, please join me in a big round of applause.